motorhomediaries.com.
My name is Richard A. Hamblen. I'm 54 years old and a native of Nashville, Tennessee. I'm a summa cum laude graduate of Vanderbilt University and a veteran of the United States Army. I have had my own business for the last 22 years. I am currently involved in a Second Amendment case before the Sixth Circuit Court of Appeals, which addresses all the issues which Heller versus Washington, D.C. did not. Up until 2006, I was a commissioned officer in the statutorily created, well-regulated militia of the state of Tennessee, known as the Tennessee State Guard. While the Tennessee State Guard is distinct from the Tennessee National Guard, it reports directly to the commander of the National Guard in Tennessee, who in turn reports to the governor of Tennessee. The Tennessee State Guard was created by law as an armed reserve force for the National Guard whenever any or all of the National Guard is called to service outside of the borders of Tennessee. The State Guard is an all-volunteer force. Each member has to supply its own uniforms and equipment. There is no pay. Practically the only thing the state provides to the Tennessee State Guard is an identification card with the state seal on it. In spite of the statutory requirement that it be an armed reserve force for the National Guard, the Tennessee State Guard possesses only 21 substandard M16A1 rifles for the entire 3,500-man force statewide. The State Guard does not even own magazines for these rifles. These rifles are defined by federal law as machine guns. The State Guard trains with these machine guns at the annual training held each summer. I have helped conduct live fire range training with these machine guns. The gist of my case is that during the run-up to the invasion of Iraq, there was a real possibility that the State Guard would be called into service. I was at the time the commander of the 201st Military Police Battalion. As I said, the state only owns 21 obsolete M16A1 rifles for the entire 3,500-man force, and it has no intention of requiring more. And this is from the trial testimony of the commander of the State Guard at my trial. I chose to exercise my Second Amendment right to provide myself and my soldiers with weapons, in the words of United States versus Miller from 1939, the only Supreme Court to address the Second Amendment prior to Heller, that were weapons that were part of the ordinary equipment of the soldier, provided by ourselves, of the type in common use at the time. The weapon in common use at this time by the ordinary soldier, as well as the type we actually trained with, is, in the words of the Solicitor General of the United States, and this is from the oral arguments to Heller in 2008, the machine gun. His actual words were, I think it is more than a little difficult to say that the one arm that's not protected by the Second Amendment is that which is a standard issue armament for the National Guard, and that's what the machine gun is. In that exchange, Judge Roberts quickly cut him off and said, this case isn't about machine guns. For my efforts, I was charged with and convicted of violating the National Firearms Act of 1934 and the Omnibus Crime Bill of 1986. The former requires payment of a registration tax to comply with the law, while the latter instructs the U.S. Treasury to refuse to accept these tax payments. So in effect, I was convicted of failure to pay a tax which the government refuses to collect. Remember, gun control is based on the taxing authority, and the power to tax is the power to oppress. If a poll tax is an infringement on the right to vote, and a tax on firearms is an infringement on the right to keep and bear arms. I was sentenced to 15 months in prison from September 2006 to October of 2007, 2 years of probation, which is set to end at the end of October. We appealed all the way to the Supreme Court. My case was at the Supreme Court at the same time as Heller. You see whom they picked to hear. The Heller decision established the right to keep and bear arms as an individual right, but the only good thing I can say about Heller otherwise is that it allowed my trial judge to grant me a certificate of appealability on my writ of habeas corpus. The trial jury in my trial in 2006 was formally instructed by the judge that there is no individual right to keep and bear arms in the Sixth Circuit under the Constitution, something which Heller now contradicts. So while Judge Campbell in his December 2008 ruling did not vacate my sentence, he did remove all the procedural objections the government could raise to my appeal, and concluded, in his words, the court concludes the petitioner has made a substantial showing of the denial of a constitutional right as to his Second Amendment claim, and reasonable jurists could find the court's assessment of the constitutional claim debatable. Accordingly, the court will issue a certificate of appealability on the petitioner's Second Amendment claim. This is critical. You know, since the case is now a civil action, I am not automatically entitled to a hearing. The judge also said in his memorandum words to the effect that there is a real conflict between Miller and Heller, but that it was above his authority to resolve this conflict, which I think is an interesting statement for a federal judge to make. So that's where we stand now in August 2009. We have filed our brief with the Sixth Circuit. The prosecution has replied, and we have requested oral arguments, and we're just waiting for an answer. While Heller established the right to keep and bear arms as an individual right, it is in fact a very limited and narrow decision. It is a terrible decision if you gauge it from how recent circuit courts have interpreted the ruling to maintain the current gun control regime. Heller states that the right to keep and bear arms is an individual right, but subject to reasonable restrictions. Well, what is reasonable, Your Honor? Anything we say is the answer. Heller is in conflict with Miller and consequently in conflict with the Constitution. But since the case is heard by the Supreme Court at its sole discretion, there is a real likelihood the Supreme Court will publicly say that it has ruled on the Second Amendment already and will never take another Second Amendment case. That is the real danger in relying on the court system to protect fundamental constitutional rights. My case is ostensibly about guns, but the real issue is the Constitution and the utter contempt in which the federal government holds them. If such a fundamental right as the right to keep and bear arms can in effect be nullified by sophistic wordplay, then what chance does the rest of the Constitution stand?